If liberty means anything at all, it means the right to tell people what they do not want to hear. Hello everyone and welcome to BYJU'S IAS exam prep and welcome to yet another video in our knowledge series. In this video, we will be discussing about freedom of speech and expression. It is a fundamental right under the provisions of Article 19 and is a right which is available exclusively to citizens of India. So, let's look at firstly the constitutional locus of freedom of speech and expression, the location of this right. So, freedom of speech and expression finds mention under Article 19. Now, Article 19 says protection of certain rights regarding freedom of speech, etc. And all the citizens shall have the right. The right are to assemble peaceably, peaceably meaning peacefully and without arms obviously, to form associations, unions or cooperative societies. The phrase cooperative societies here was added in 2011 through the 97th Amendment Act. And then to move freely throughout the territory of India, to reside and settle in any part of the territory of India. Now, Article 19, Clause 1, Subclause F has been repealed. It was basically the right to property, the right to acquire, hold and dispose of property, the right to purchase property, the right to keep property and the right to sell property as and when you want to. However, in 1978, via the 44th Amendment Act, this right was actually repealed. As of now, right to property is available for all people, irrespective of whether you are a citizen or not, and it is a constitutional right and not a fundamental right. And finally, Article 19, Clause 1, Subclause G, POTB, that is to practice any profession or to carry on any occupation, trade or business. So these are the provisions under Article 19 and our focus here is Article 19, Clause 1, Subclause A. Interestingly, when you talk about freedom of speech and expression, the idea is that you should be able to express yourself freely. But all rights in our country come with restrictions. Unlike, say, if you compare the rights in USA. Why USA? Because we have drawn inspiration from USA insofar as our fundamental rights are concerned. So in USA, rights are absolute in nature. Whereas in India, the rights are qualified in nature. Restrictions can be imposed on the use of the fundamental rights. And you can find out that the rights in our country can have restrictions imposed. Restrictions, however, should always be reasonable. They cannot be unreasonable. And number two, restrictions can be imposed only by a law and not an executive action. So, Article 19, Clause 1, Subclause A has the restriction mentioned under Article 19, Clause 2. Article 19, 1B has restriction under Article 19, Clause 3, so on and so forth. So let us look at Article 19, Clause 1, Subclause A further through its restrictions. So what are the restrictions that are mentioned in the usage of our freedom of speech and expressions? First up, and also let me remind you, say in a country like USA in their first amendment, it does find a mention that they have freedom of speech and expression. Also, they have exclusively mentioned that they have freedom of press in the country. In India, freedom of press is not exclusively mentioned, but it has been read into. And the Article 19(1)(a) also means that we have freedom of press in the country. So yes, there is freedom of press, even though not mentioned in the Ramesh Thapar judgment 1950, or Article 19, Clause 1, Subclause A also says we have a right to know. That was said in the Raj Narayan case 1975. Or right to access information over the internet. That's also a part of freedom of speech and expression. So not the right to use internet as said by the Kerala High Court, but Supreme Court later clarified in the Anuradha Bhasin case of 2020 that yes, every citizen has a right to access information over the internet, because without information you may not be able to express yourself truly. So these are also elements in the freedom of speech and expression. Now beyond this, as you are aware, Article 20 talks about right to remain silent. Just like you see in the Hollywood movies, when somebody is arrested, the police officer says you have a right to remain silent. The same thing is applicable in India also under Article 20, that there is no self-incrimination. You have a right to remain silent. Also, as far as the freedom of speech and expression is concerned, the mirror opposite is also available. You have a right to silence. So you can choose to remain silent or you can choose to express yourself. Being silent is also a form of expression. Anyway, now coming down to the restrictions that can be imposed on our use of speech and expression. First things first is the sovereignty and integrity of India. Now this was not originally there. It was added later on through the 16th Amendment Act in 1963. That was after the Indo-China War. We added this particular line as a restriction. Then the security of the state, then the friendly relations with foreign states, public order, and incitement to an offense. So friendly relations with foreign states, public order, incitement to an offense, these have been restrictions which have come under Article 19 Clause 2 through the First Amendment Act that was passed in the year 1951. And then other things like decency, morality, contempt of court, defamation. So these are all restrictions on our free use of freedom of speech and expression. So let us look into what some of these restrictions actually mean. First up, we have incitement to an offense. Now, as far as incitement to an offense is concerned, when you use your freedom of speech, of expression, Kedar Nath case 1962, the Supreme Court clarified that discussions in our country, discussions on any topic, however annoying they are, however irritating they may be to you, they are always allowed. There is no limit that can be placed on the freedom of discussions. So you have a right to discuss anything. However, a step further, if you want to advocate something, if you want to preach something, then whatever you want to advocate should be within the framework of the Constitution. So if you want to preach something, it better be within the framework. So it is allowed, but it should be within the broad framework, the confines of the Constitution. So even advocacy is allowed. But what is not allowed is incitement to offense. Meaning, if you make a speech and somebody gets inspired by the speech and commits an act of violence, creates any kind of public disorder, something which violates public order, then restrictions can be imposed through various laws in our country. You can be jailed as well, you can be punished, penalized, fines can be imposed on you if through your speech or expression there are people who have been forced into committing some activity, some action which hampers public order, disrupts public space with respect to some negative behavior. And this is what actually is referred to sometimes as hate speech. A small part of it is hate speech as well. When you make a speech which motivates people to commit an act of, say, terror, any act which is violative of the laws of this country, and any act which is a criminal activity. So yes, the restrictions on our freedom of speech are there only if somebody commits an offense and there is a direct relationship between your speech and the offense the person is committing, right? But discussions and advocacy are always allowed. Now, insofar as this freedom of speech and expression is concerned, plus something which creates incitement to an offense, there is a draconian law in the country, and this law is the law of sedition. Sedition as per the provisions of IPC section 124 capital A. Now, if you look at IPC 1860, the Indian Penal Code, in the Macaulay's IPC, it was not there as a provision. It was only added by James Stephen in 1870 to place a limitation on the anti-British government activities, the anti-British India government activities which were happening in the country. And it was added later on in the IPC to punish those people who were spreading disaffection in British India. Now, sedition, I'm sure you must have heard of this particular term and this law. There is a huge misconception on what exactly is sedition. A lot of people believe that sedition is, curbing anti-national behavior. However, let us look into what is the definition of sedition under section 124 capital A. So this is what is the definition. Whoever by words, either spoken or written, or by signs or by visible representation or otherwise, brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection. Fair enough. So anyone through their speech or expression tries to bring into hatred or disaffection against what? The country? No, not the country. Towards the government established by law, they shall be punished. So this sedition is not preventing anti-national activities, it simply prevents anti-government activities. That is what sedition prevents, anti-government activities. Obviously, this law made a lot of sense in British India because it was a foreign government and we were trying to overthrow the government. And that is why the Britishers did not want this to happen. They were against any kind of propaganda, against the ill treatment that was being meted out to Indians for a long period of time. They wanted to curb our speech and expression. They wanted to curb any kind of dissent, and hence this law. And look at the punishment. I mean, if you see various laws, the punishments are normally up to 6 months, up to 2 years, up to 7 years. This means you can be punished anywhere between 0 to 7 years, 0 to 2 years, 0 to 5 years. But look at the punishment under sedition. With imprisonment, you will be punished with imprisonment for life. Life imprisonment, just for raising your voice against the government, to which a fine can also be added. Or alternatively, you can be punished with 3 years of jail. Nothing in between. It's 3 years or life. Or there can always be an option of fine. So look at the draconian punishment. 3 years or life imprisonment. For what? For raising your voice against the government. This is hilarious. And interestingly, the government has always put forward this idea that the justification that the government gives is that it is very useful in curbing anti-national activities. Now, strangely, this law does not talk about the nation, it talks about the government. Then the government says it is very important to have a check on the terrorist elements, and this law helps in doing the exact same thing. But sadly, we also have another law, UPA, Unlawful Activities Prevention Act, which does the same thing. So why the need for sedition? Then the government also gives a justification that sedition also prevents in overthrowing an elected government through illegal means. We can counter that also by simply saying that we already have a provision of Article 352 which says that national emergency can be proclaimed if there is any armed rebellion in the country. So that's also there. Then some other arguments. For example, a lot of people believe that it will counter the Maoist insurgency. We have plethora of laws under CRPC, under the Arms Act to prevent such activities. We don't need sedition as a law. And lastly, the government argues that look at judiciary. Judiciary enjoys the contempt parts. You cannot make statements against judiciary which lower the dignity, which attack the authority. Why should the government not enjoy the same contempt powers? That if you make statements which are derogatory to the government should have the right to punish you. It is funny because this is democracy. Dissent is extremely important. In fact, dissent and criticism of the government are essential ingredients of vibrant democracy. And here we have the governments saying that you should not spread disaffection or hatred. Don't question the government. See, the governments have to realize one thing. Affection cannot be manufactured. Governments don't have a right to be loved. It's a feeling which is generated if you behave well. If there is good governance in the country, people will love you. You can't manufacture it. And because you are somebody who is elected by the people, people have a right to vote you out. Why should the people not have the right to question you? This is a law which is a relic of colonial legacy. It has no place. It is unsuited in a democracy. It should go away. In fact, the country UK, which had brought this law in our country, abolished the same provision in their own country. But sadly, we continue it. And see the words here: disaffection, hatred, contempt. These are all vague words which are prone to misuse. Every year, hundreds of people are arrested on account of sedition. Whether you appreciate their views or not is of no concern. They have a right to question the government. The time has come for this law to go away. But you know what? On the 11th of May, a very important decision was taken by a 3-judge bench consisting of the Chief Justice of India, N.V. Ramanna. Also, we had one Justice Suryakant, who is currently in the spotlight for his comments, and Justice Hima Kohli. Now, the matter in the court was on the constitutional validity of sedition as a law. So, the 3-judge bench was pondering on whether to transfer this case to a larger 7-judge bench or not. And then the government said that, sir, my lords, please give us some time and we will look into whether this law should remain or not. And we are going to reconsider on the constitutional validity of this law. So Supreme Court said, okay, take your own time, but as an exercise of caution, on the 11th of May 2022, a very unique step was taken. Supreme Court said, and they chose rather to exercise an additional layer of caution, stating that no coercive action will be taken in the sedition cases which remain pending in front of the police, the courts, until the union re-examines the law. Plus, no more new cases to be filed till the government takes a stand on what exactly and where do they stand on sedition. So thankfully, no more cases will be filed, at least on paper. We have known that this does not really go down or travel far and wide because awareness is very important. We have to make sure that people are now aware that sedition is a law which is slowly moving towards its demise, thankfully. And if the government does not do it, we believe that the Supreme Court will definitely take an action and remove this draconian law, which was called as a prince amongst all the laws that the Britishers had brought. And this was a law which was used to harass every freedom fighter in this country. So that is all as far as sedition is concerned. And this was an extension of the incitement to an offense. Now, one more key word, which is a restriction, is a very unique word. And this is defamation. It's also under IPC. One section 499 defines defamation, and section 500 talks about the punishment which can be imposed with respect to defamation. Now, why the picture of these two gentlemen? So there was a case of defamation. Let me explain what is the definition of defamation. So defamation can be of two kinds, not civil or criminal, but also libel and slander. It can be in two forms. One is libel. Libel simply means something which is addressed to the eye in written form. And we have slander, something which is addressed to the ear in the spoken form. So defamation is a situation where any person who by spoken or written words, signs or visible gestures creates or publishes any imputation. Imputation means accusation on any person with an intention to harm the reputation of that person. And not to forget, the person making such accusations should have the knowledge or a reason to believe that such accusations will ruin the reputation of the person. Now let's come back to this very interesting case that happened. So a couple of years back, the favorite star of most of the people of this country, Mr. Salman Khan, he released a physics-defying, logic brain-defying movie called Radhe. And then what happened? This gentleman, Kamal R. Khan, he does reviews on YouTube on various movies. And while doing a review on that movie Radhe, he made some derogatory remarks on the age of Mr. Salman Khan. And he repeatedly referred to him with a certain term, which is otherwise a very lovingly used term for our grandparents, but not so much if you are an actor who's trying to play a younger role. Anyway, so the team, Salman Khan, was very angry and upset, and they said that this is causing defamation. This is what is, hurting my reputation in society. Even though I may be 58, 59 years old, I don't look like one, or I'm not playing a role like that, so please don't call me that. So the matter went to court, and now comes the issue here of what is the punishment. So defamation can be of two types. It can be either civil, when you say that somebody has made a statement against me and my reputation is damaged in some monetary compensation. I need money. My reputation worth 10 crore rupees has been damaged. Please pay me 10 crore rupees. So when you seek monetary compensation, it is called a civil defamation. But if you say, no, I won't settle with money, money will do no justice, I want to see the other person in jail, that's called a criminal defamation, where the punishment can be jail sentence of up to 2 years or fine or both. That's very unique and interesting. Criminal cases where you have to go to the court, you have to attend the court cases, right? It's a harassment in itself. So it's both civil and criminal. A few years back, in one Subramanian Swamy case, this matter came in the court whether defamation should be a criminal offense if you make fun of somebody and you damage the reputation. It's seen by people as a very personal thing. It's a private dispute. Why should the public resources of police be involved in settling private disputes? This matter was taken to court. And then the court asked the government, what do you have to say about defamation being a criminal offense? And the government said, sir, we have a right to protect the reputation of citizens. So, criminal offense, defamation being a criminal offense is something that we support. And Supreme Court agreed. In the Subramanian Swamy case 2016, Supreme Court said that every citizen has a right to reputation. Article 21 provides with this fundamental right to reputation. And it's the duty of the state to protect the reputation of the citizens, of the people of this country. And hence, the defamation continues to be a civil as well as a criminal offense where you can also be jailed for it. Interestingly, there are a lot of issues and concerns with defamation. First things first, how do you assess the monetary damage? And we have always seen exaggerated valuation of damage. That's one big challenge. How do you assess that your reputation has been damaged with 10 crores or 100 crores or 1 lakh crores? We saw the defamation case between Mr. Depp and Ms. Heard just recently, right? And we saw the huge suits being filed worth millions and millions of dollars. So arriving at that figure is very unique. How do you arrive at a figure? There is no fixed criteria, no guideline as such to help you in arriving at that particular magical figure that this is the amount of harm that has been caused to me. First thing. Secondly, it can always be a case that you feel, you read something and then you get offended and you file a case in multiple courts across the country. And then the person against whom these cases are filed, he has to run from this court to that court. You start your journey and you have a Bharat Darshan of sorts. You go to the Calcutta High Court or maybe some court in Tamil Nadu, somebody files a case in Jammu and Kashmir, somebody files a case in Gujarat, and you keep on moving from here to there. And then you go and approach the Supreme Court that, sir, there are so many cases of defamation against me filed in so many courts across the country. Please transfer the cases to Delhi. It'll be easy for me. And then the Supreme Court may pass some sarcastic remark on you. That is also possible. Then a very unique problem with defamation, and a lot of people accuse that this law is something which is an exclusive preserve of the rich and elite only. This law is exploited primarily by the privileged groups. Let's say you purchase some new dress and you upload the photographs on, say, Instagram in hope of getting some likes. And when you upload the photographs, people start commenting, stupid dress, looking so funny, so silly, disgusting. And they make all these laughing emojis. You feel bad. What do? Maybe you will shut down your computer, sit and cry, go out, fresh air, come back, it's okay. Or you change your password, you maybe remove Instagram for a few days, a few months, that's all you will do. You will not be bothered about all these things. You won't go to court and file a case that some people have made a comment about my dress. No, it's okay. You move on. These kind of laws are used exclusively by the rich and elite. And plus, we are obviously wasting the public resources in exploiting or in settling something which is actually a private dispute. So these are all contentions with respect to the criminal aspect of defamation and defamation in general. However, this is a law, and if you damage the reputation of any individual, you can be punished. Either you will have to pay some monetary compensation, or you will have to be served a jail sentence, depending on what kind of case you file, what are you seeking, what satisfies you. So this is defamation. Now, one more interesting thing, contempt of court. This is also a limitation imposed on the freedom of speech and expression. So what exactly do you mean by contempt of court? Contempt of court can be of two kinds. Number one, civil. Number two, criminal. A civil contempt means if somebody willfully, knowingly, deliberately disobeys the lawful order of the court. If you deliberately do not obey or disobey the court's order, a civil contempt can be issued against you by the court. Secondly, a criminal contempt. If you make any kind of statement, you write an article, you express yourself in any form or manner which scandalizes the court, meaning horrifies the court, which attacks the dignity of the court, which lowers the authority of the court, which obstructs the course of justice. In all these circumstances, a criminal contempt of court can be issued against you. There is a law in the country, the Contempt of Court Act of 1971, which provides for punishments. Punishments that can be imposed on you. The punishment is not huge. It is just 6 months, up to 6 months of jail, or a very small fine. The fine can be up to 2,000 rupees. So this is the punishment that can be imposed on you if you are involved in misusing your freedom of speech and expression to attack the dignity, to hamper or tamper with the independence of the judiciary. So this is basically contempt of court. A very famous case with respect to contempt of court was the Prashant Bhushan matter, which was up for discussion last year. So Prashant Bhushan had made some remarks on a social media platform against one former Chief Justice, S.A. Bobde, when he was seen riding a Harley Davidson custom vehicle bike, right? It was a CVO 2020 edition that S.A. Bobde was riding, and it was a bike of some BJP worker in some city. And he made some allegations which were baseless. Now, as far as contempt is concerned, fair and accurate reporting of judicial proceedings is not contempt. As far as contempt is concerned, fair criticism is not contempt. So there are some things which are not contempt. If you back your accusations with facts, that is not contempt. But he made some allegations without, he made some suggestions, imputations, and he did not back them up with any kind of fact. Supreme Court called him up and said, please apologize. But he said, no, I won't. And then an exemplary fine was imposed on him. A fine of 1 rupee was imposed on him. And interestingly, Mr. Prashant Bhushan refused to pay that fine also. Finally, somebody else paid the fine on his behalf and the matter was closed. So you see, sometimes contempt of court is issued against people for various situations. Now, contempt of court can always be issued only by a court of records. Like in our country, under the provisions of Article 129, Supreme Court is a court of records. Under the provisions of Article 215, High Courts are court of records. So Supreme Court and High Courts have the power to issue for contempt of themselves and the lower courts as well. The subordinate courts don't have the power to issue for contempt. Right? Secondly, who can start this case? The complaint in this case can be filed obviously by the Supreme Court or by the High Court, the judges respectively, or the Solicitor General, the Attorney General at the Supreme Court level, and the Advocate Generals at the High Court level. These are also people. So let's say you read some article somewhere which is very scathing in its remark on the Supreme Court. What do? You read the article, you feel very bad. How dare the people, how dare this author make some remarks on my Supreme Court? You feel very angry. You are allowed to file a case, but your case will only be accepted if in the Supreme Court, if either the Solicitor General allows or the Attorney General allows. And if it's the High Court, your case can only be accepted if the Advocate General allows the case to be accepted. So yes, common people can file a case, but it should be approved by the respective law officers of the country. So this is all that we need to know as far as the contempt of court is concerned. So these were the restrictions in the Constitution insofar as the use of freedom of speech and expression is concerned. So now I'll take up some questions that you have. Feel free to ask questions. Okay. T. Gingolan, does Article 19 or is Article 19 available during emergency? It depends. So as far as the provisions of Article 358 are concerned, if the emergency has been imposed on external reasons, for example, if the emergency is imposed on the grounds of war or external aggression, then Article 19 gets suspended automatically. Also, if the emergency is imposed on grounds of internal disturbance, which is no longer a word now, we have armed rebellion instead of internal disturbance, thankfully. So if emergency is imposed on the grounds of armed rebellion, then your right to move to court for the violation of Article 19 can be suspended if the President allows for it. So yes and no, depending on situations. So one is 358, one is 359. Ravi, can't some TV channels discussions which seldom sound annoying be restricted? Now see, as I said, discussions, however annoying they are always allowed. Mind you, if somebody starts preaching something, advocating an idea which goes outside the scope of the Constitution per se, that becomes a problem. That is not allowed. So yes, if you find annoying, as it is said, you are free to change the channel, right? And if you find in any TV channel, if there is something being preached which violates the fabric of this country, the socio-economic and cultural fabric is being threatened, feel free, file a case. Aditya, on what basis there is advocacy for banning loudspeakers in public space? Right under Article 21 to a noise-free environment. So every individual has a right to a noise pollution-free environment, and that is why if you feel that your right is being violated, in that sense you can always approach the court and asked for the banning of loudspeakers. Abhinash Nayak. So one doubt, we see every now and then criticism of government in many situations on many platforms in news, YouTube. Are they ever punished under sedition law? Abhinash rightfully pointed out, sedition is a law which is now, hopefully it will not be misused, but was primarily being used very, very selectively. To give you an example, see, you may agree with somebody's ideology, you may disagree with their ideology, but we will go to extreme extent to protect the rights of people, unlike the so-called pseudo-liberals of the country who are very selective in nature. So it does not really matter whether you agree to their views or not, whether you're right wing or left wing. If somebody's rights are being violated, we'll go to the very extreme extent to ensure that your rights are protected. For example, a very famous journalist, Vinod Dua, who passed away recently, he had a very interesting show a few years back, Zaika India Ka. Anyway, he now was a part of a channel which was primarily on YouTube and also runs a website. And he, in some of his videos, was making remarks against the government, going to an extent to say that the government is winning votes on the dead bodies of the soldiers of the country. And some BJP leader somewhere became very upset and filed a sedition case which was registered by the police. Yes, it is wrong. I mean, in a democracy, we have a right to criticize the government. I know the country is not as amazing as some news channels call it to be, but the country is not as bad as some other news channels make it out to be. We are always in this area, the zone of growth and development. So yes, this country has problems. As I've always said, we don't need some stand-up comedian to tell us that we have problems. We do have problems. We'll settle those problems through discussions, deliberations, and debates. But if the criticism of the government is stopped, if dissent is suppressed, it will create a situation where we'll have a despotic rule, dictatorship, that can never be supported. So obviously, whoever you are, whatever your ideology is, you have a right to question the government, because this setup is a democratic setup. The people of this country have the real power. That is how it is supposed to be. We, the people of this country, have given to ourselves this constitution. Okay, one last question. Dejan. CRPC 144 is also a tool used by British to suppress Indians, but same law is being used to suppress Indians and to many extend rights are. When it comes to usage of section 144, 141 or other similar provisions, let's say banning of internet under the Telegraph Act, all these things, the problem is it is very subjective, because we have to rely on the local magistrate, the district magistrate, the SDM's understanding of how serious the situation is. So it is very subjective, and hence it is prone to misuse. So there are cases where sometimes the use of curfews, the use of 144 becomes very important because there is a genuine threat to public order. But on certain occasions, it may not be that important. The issue can be resolved very peacefully, but still the executive, the officers there very easily go and impose these rules, these laws. And yes, that's true. In our country, the fundamental rights can be curtailed even when some executive at a very lower level exercises his or her power in pursuance of the provisions of IPC and CRPC. That's true. Modifications are required, but the better way would be to make people, the executive, also understand the importance of these words, and a larger understanding has to be developed with respect to when to use the powers to curtail the rights of people. Obviously, we're a country where the rights are limited, but this does not mean that we get this unfettered right to do whatever we want to do. Our freedom of speech, expression, or any other right is always restricted, and the restriction should be, however, reasonable. So that is all as far as this video is concerned. We'll meet in the next video. Till then, that's all for us. Jai Hind.